Good evening, everybody. Jonathan here. Hope you are all having a nice week. No hurricanes right now, which is a good thing. And hopefully we won't have any more really serious hurricanes. I know we have some friends in Asheville who are still digging out from that. And I think that the one that was last week, Helene, I think, left quite a trail of devastation in Florida. So again, if you're dealing with that, thoughts are with you. Um, we're getting a little bit of a cool breeze here in Atlanta, where I'm at. The high was 60 today, so this is the first couple of days we've actually had fall weather. So I hope wherever you're at, you're getting nice weather as well. So anyway, that's kind of where I'm at. And again, I hope that again everybody's doing well, and we hope we'll have some nice questions today. Let's go ahead and start. So Christina, one of my loyal viewers, makes note every week to like, share, comment, and subscribe, which I really appreciate it. You can hit the like button, leave me a comment, post a question, and of course, subscribe to the YouTube channel. That would be very, very helpful. Hey, Gary, how are you doing? Okay. Let's see. Younger than me. I'm younger than you, I guess. I'm not younger than a lot of people, but I guess I am. Coworker statements, and I worked for 1.5 years with this work now. Yeah, and I think what Gary's getting at is one of the things that I think is a very effective type of evidence you can use is a statement from a coworker, former coworker or supervisors. Remember that the main issue in a disability case has to do with your capacity to be a reliable employee, right? So if a former coworker says, I worked with Gary back in 2022, and the last 6 months he was a really hard worker. The last 6 months of our time there, he was having a lot of trouble with attendance. He was clearly was in a lot of pain, whatever the case may be. And now you have a third party who doesn't really have a vested interest. It's not like it's your wife or your brother or sister or parent. This is someone with a third party to basically say, this is what I've observed. And some judges, not all, but some judges find that very, very persuasive because, again, this is a third party statement. Somebody observed you at work. I mean, what better evidence can there be about your work capacity than someone who actually saw you, who can talk about some of the issues you had? So I think that even if it's a 1.5 years old, it's still relevant because realize your onset date assuming your onset date is a 1.5 years ago, then that's very, very relevant. Even if your onset date was after that, this kind of gives a sort of a historical, view, a point in time as to what was going on with you, a 1.5 years ago. So absolutely, I think that's would be very, very helpful, and I would get those in. Now, is that going to make or break your case? Is that going to, cause you to win or not win? No, but I think it can be helpful. In fact, there was a number of years ago, there was a like a listserv that judges, and adjudicators would, communicate with each other on, and it was public at one point, and so you could see. You couldn't comment on it because it was, again, just for professionals and Social Security, but you could see what they wrote. And I remember there's one thread I read where a judge says, that in his opinion, this one judge, statements from a former coworker were extremely persuasive, and I agree. I think that's really good evidence. Certainly can't hurt. Certainly can't hurt. Now, I will say one other point, though, is the way Social Security rules work, if you have evidence that is, written evidence, you've got to submit it, good, bad, or indifferent. So obviously, if you're going to ask a coworker to write something, talk to that person beforehand to make sure that what they're going to say is going to be helpful to you. If they're not able to say anything helpful, or if they have no memory of it, then don't ask them for the statement. So just be aware that if you get the statement, though, you're required to submit it. Okay, now we have a question from Ruben. I contacted my orthopedic doctors about filling out a functional form, and they refused to do it. What should I do next? And what Ruben's getting at is that there are forms, and I know I've given them to you here, functional capacity forms, where basically the doctor is offering an opinion about your capacity to be reliable at various elements of work, lifting, carrying, sitting, standing, using foot controls, using hand controls, climbing ladders, maintaining attention and concentration and focus, just any number of things. And so a functional capacity form, can be very, very helpful evidence, because you're asking the doctor to really translate your medical problems into very specific work limitations. So if you can get one, that's great. It used to be, I'd say 15, 20 years ago, I really, really put a lot of emphasis on having them, because, you needed to have a doctor's opinion about it for the judge. Now it's helpful if you can get one, but a lot of doctors won't do them. They don't either want to get involved, or they don't have the time, or they want to get paid a bunch of money to do it. So I don't think it's as necessary. What I'm really going to be looking more at is, and I've won plenty of cases on a good medical record. If it's orthopedic, you need to have objective tests, an MRI, a CT, discogram, something that documents what's going on with your back or knees or shoulder, whatever it may be. So I think if you've got objective evidence, and you've got evidence that the doctor has treated you without success using medications, physical therapy, TENS unit, facet injections, epidural injections, Neurontin, muscle relaxing, whatever it would be, and it's not working, you can draw an assumption from that you have significant functional limitations. I was doing a pre-hearing brief, working on it yesterday and today, for a client. We don't have a functional capacity. Well, actually, we have one, but it's from a doctor who saw my client one time. It's not going to really carry a lot of weight, I don't think. And this poor lady has been really for 4 years now, 3 to 4 years, has been going to doctors. She has disc bulges. She has documented problems, but she's not surgical. She doesn't have a herniated disc can be repaired in surgery. She doesn't need a fusion. So basically what they're doing is, she's gone to physical therapy umpteen times. She's got, she's getting epidural injections that last two weeks to 2 months. She's on Neurontin, which makes her sick. Gabapentin or Neurontin makes her sick. She's had a TENS unit. She's had facet injections, epidurals. Nothing, it may help for a week, but nothing really helps. So, I wrote my brief, so far it's about 4 pages, which is longer than I like, where I'm just going through, this poor lady has gone through, she keeps going back to the doctor, trying to get relief. And so the point I'm making in my brief is, even though I don't have a really strong functional capacity form, if you look at the record, you can see that this lady has been going to the doctor repeatedly to try to get relief. She's done everything they've told her to do. The doctors all recognize that it really doesn't really work, but she's between a rock and a hard place, because she's not a surgical candidate. So, that I'm kind of doing by implications that her capacity for work has been greatly reduced. This is another case, by the way, which is kind of a twist to it. She's now 51, 52, but her onset date, she was like 48. So, and I'm going to suggest to her that she amend her onset date to her 50th birthday, so she'll meet the grid rules at age 50. It will cost her about a year of past due benefits. But this is a kind of case, I can tell you from experience, we don't have an MRI that shows significant herniations. It's bulging. It's something there, but it's not incredibly, that you can see why this person would have, just not able to function at all. But there's enough there to support the symptoms that she's got. But it's going to be hard to prove that she can't do anything at all before age 50. And at age 50, I have the grid rule. I can argue that she's limited to sedentary work, and even the consultative doctor said that, limited to sedentary work, and because of pain, medication side effects, would not have any transferable skills. And her job is one where there's really not a lot of transferable skills. So that's what I'm going to recommend to her. I think that's a winning argument. Big picture, I know I've been blabbing about this. We don't have a really strong functional capacity evaluation. Let's assume we don't have it at all. I'm going to be able to make my argument based on the medical record, based on the objective test. And Ruben, that's what I would tell you to look at. Look at the objective test, look at the medical record. What can you assume? What can you glean from that about your capacity for work? And can you make an argument that maybe you meet a grid rule, or that your capacity to work has been greatly reduced? Okay. Lopsided Laurie. So Laurie sent me a number of questions here. So I'm going to kind of go through these. That it looks like she got a partially favorable. There's some issue with self-employment taxes. Um, it looks like she had breast cancer. Um, there's a lot of stuff going on here. This is one of these cases, I can tell you, Laurie, where it doesn't fit a pattern. It's an unusual case. And what you're doing, going to your congressional representative, makes the most sense. That's the person who can try to cut through the red tape. When you talk about losing your file, that's what they'll do. Basically you have an overworked person at Social Security, and I'm not making a generalization, but you have somebody who doesn't want to deal with all the nonsense. Maybe somebody screwed up. Maybe there was a problem in terms of calculating your self-employment tax. A conclusion was made about your working that's not correct, and somebody has to go in and take responsibility and undo that. And they don't want to do that. They don't want to do it. So they're just trying to stonewall you to make you hope you go away. And what you're doing, which makes a lot of sense, is to reach out to your elected representative and say, I need help, because they're stonewalling me. They're not really helping. Now, you said it took away $80,000 in back pay. That's pretty significant. You want to sue. You can't do that. I will tell you, you can't sue them for emotional distress because there's something called sovereign immunity. So that's not going to really work. But I think your congressperson, and really maybe get a senator involved too, you have to be the squeaky wheel to get the grease, because if you don't do anything, they're not going to do anything, and you're going to just have to keep fighting it. The issue you run into in terms of getting an attorney is, attorneys like me, we do disability hearings, we do cases trying to get people on benefits. When you have one of these really unusual situations, you need to almost get somebody who is looking at this almost like and maybe a contract lawyer is not the right type of person, but someone who is knowledgeable about federal bureaucracy, who can go in there and make some waves if need be. But most disability attorneys like me, that's not what we do. So you're going to have a hard time finding a person who markets themselves as a disability attorney to go in and deal with this, because again, it's just outside what we do. Greg Brinkley, and Greg has been on our live stream before, he might be able to offer some guidance. His email is Greg, G-R-E-G, at gregbrinkley.org. There's another gentleman named Ed Weir, W-E-I-R. You can look him up. He used to work for Social Security. He might be able to help a little bit. So you may have to just pull some strings, but I think going with your elected representative is probably the best thing you can do, because this is one of those unusual cases where, if you had to put an attorney on retainer, you could spend a lot of money, and you're going to have to, most attorneys who would do this, if you're going to have somebody on retainer, they're going to want, $5,000 or $10,000 up front. And that's where the problem is. But you've got a lot to, you've got obviously a big problem, $80,000. They made a mistake, and you got to get them to admit that they did. That is going to be an uphill battle, but hopefully you can get it done. Definitely let us know. Okay. Lil Smart in Southern California, I'm fighting SSDI for alleged $56,000 paid in benefits. Not sure if you mean they're saying you were overpaid or that you haven't been paid. If you would tell me a little more about what you're asking, that would be helpful, because I'm not sure what you're asking. Again, it's an overpayment. It's one thing. If it's not paid, that's something else. Jim is another regular. Is it okay to ask for an on-the-record decision before a scheduled hearing? Yes. In fact, most of the pre-hearing briefs I do double as on-the-record and pre-hearing briefs, where you lay out the theory and you ask the judge to go ahead and grant. And it's happened. I've had it happen a few times. So they can be one and the same. So you can do an on-the-record pre-hearing brief could be the same thing. Okay, St. Louis Grand. Let's see. Federal, one of two. He found a case that said the ALJ cited the fact that the claimant was able to conceive a child as part of their rationale for denying the case. What it's getting at is, what is an appropriate grounds for appeal? And I think, the case that St. Louis came back with was that an ALJ, administrative law judge, was reversed by the district court, because one of the reasons he said a person could work was, well, you could conceive a child, therefore you can work. Obviously, that's absurd. That's ridiculous. I will tell you, though, that in hearings, if I have a client with young children that they're the client's caring for, male or female, 2-year-old, 3-year-old, judges will ask a lot of questions about that. Who's dealing with the day to day? Who's, making sure that the child is properly, clothed and fed and bathed and things like that. I have a 13-month-old granddaughter, most beautiful little baby you could ever hope to imagine. But that's, of course, my thought, my bias. But she's a sweetheart. She's a really good baby. She eats really well. She's just very good natured. But my wife and I watch her one day a week. My sister-in-law watches her a couple of days. My wife and I watch her one day. My daughter and her husband, take one day. They kind of work around their work schedule. His parents watch her one day, and my wife and I watch her one day. Today, Wednesday, is the day we get her. And I will tell you that it's a lot of work to care for a young child, for an infant, a toddler. I can't, let her out of my sight. She doesn't understand when you're climbing on a stairs that you can't just turn around and start walking the other way. She'll fall down the stairs. So you have to watch them. It's a lot of work. And if you have a problem, medical problem, where you need to take unscheduled breaks to lie down and sleep, you can't do that if you have a 1-year-old in the house. If you can't lift things, you can't take care of a baby because babies sometimes have to be picked up. My point is simply that, I think that the idea that, being able to conceive a child is not evidence of being able to work, but I think caring for a 6-month-old, a 1-year-old, a 2-year-old, that is evidence of capacity that, is in many cases as much work as any kind of job you could do. You got to be focused. You got to be paying attention. You have to have a certain amount of strength and coordination. You've got to be able to react quick, and you've got to be, really on the ball. So I think taking care of a child is similar to work in many respects. And, now, again, people will say, well, I get help, but you have to prove that. So if, let's say you're a grandparent, or you're an uncle or an aunt or something like that, and you're trying to take care of a baby, and you have help from an older sibling, or you have help from another relative, you need to get that person to put in writing what they do and what you do. Because again, a judge sees you being responsible for taking care of, a baby or a 2-year-old or a couple of kids. They're going to assume if you can do that, you could work, because the converse of that is, a judge is going to look at you and say, well, I think, what you may be doing here is you're applying for disability so that you can get a paid stipend for taking care of your baby by being on disability. And then obviously, you've got to be disabled, not caring for a child or an elderly person. So just be aware of that. But I would agree that, simply because you can conceive a child does not make you disabled. Okay, Jen, my senior paralegal is online. Hello, Jen. How are you doing? Joe, good evening. Contact the hearing office. Joe had a hearing, and he's asking for the transcript. I know you can get a copy of the recording. I don't know if you can get a transcript, but maybe. Be interesting. Sandy says they have freeze warnings. We actually are having, I think, frost tonight. I think it's going to get to like 35 or 33 here. So it's going to be kind of chilly. Again, it got to 60 today. I'm supposed to play tennis tomorrow. Let me see what it's supposed to be tomorrow here. Let's take a look. Yep. Tomorrow is going to be 64, 37 and 64, sunny. So it's going to be chilly, not ridiculously bad in the afternoon. But it's not going to be, not going to be great. Oh, by the way, there will not be a live stream next week. I'm going to be out of town. I go every year with some buddies of mine. We go down to the Florida Panhandle, play tennis, eat pizza. None of us are drinkers. We don't drink or anything like that. We just eat too much, eat desserts, eat pizza, play tennis, and just kind of, hang out for 3 or 4 days. A buddy of mine's family has a condo, so it's a free place to go. So I will not be here next week, and I thought I could theoretically do it from down there, but I'm not going to ask the guys to, to vacate, 2 hours at night. So 99% sure I'm not going to do this next week. I'll put something out there, but that's the likelihood. But I'll be back the following week. Okay, Trish. Hello, Trish. How are you doing? How long do you think Jose or Joe wants to know? how long to get the transcript. I don't know. I've never actually gotten a transcript. I've gotten the, I believe at district court you can get them. I don't know if you can get them at the appeals council level. I don't know. Um, um, Joe says typing on a tablet's not as easy as a phone. Yeah, I have an old iPad, and I've got actually one of those keyboards, and that's okay. But it's not really the same thing as, look, even the phones. I mean, I find it hard to do too much typing on a phone. It's just the keys are really, obviously it's very small. My wife is of the opinion that being an occupational therapist for thumbs is going to be a real growth industry because of all the stuff on all the people that use their phones. Vince, how are you doing, Vince? Vince is one of my clients. I hope you're doing well tonight. Antonio from Florida, 59 with medical issues. How long will it take for you to receive SSI? Well, again, that's kind of a loaded question. So, obviously you have to apply. The medical issues have to be serious enough to keep you from working. And in a best case, Florida is one of the worst states as far as the delays. In a best case, if you apply and you have a really, really severe impairment, you may get a decision, hopefully a positive one, in a year, 11 months, a year. If you're denied and you have to appeal it, reconsideration hearing, you're looking probably 2.5 years. So best case about a year, worst case, to get a decision about 2.5 years, and whether you win or not is going to depend on the severity of your impairment. Hey, Kelly, you filed for recon in September. What are the next steps to take? What do you think the timeline is? Okay. Well, I mean, it kind of depends on the state, but generally speaking, you can expect to wait anywhere from 6 to 12 months for a recon decision. They will probably send you forms, activity forms, pain questionnaires. There's any number of forms they have to send you. I think some of it's to kind of keep you busy, busy work, but they'll send you some forms. You want to get those back as quickly as you can. The recon adjudicator will probably send you out for consultative evaluations. So go to those. And obviously keep the adjudicator updated as far as any doctor visits, any change in medication, any change in, if there's surgery, something major goes on. So there's really, in terms of next step, it's really updating them, keeping them updated, and then just waiting until they make a decision. And again, it'll be 6 months to a year before you get a decision. If you're turned down, which at recon, not uncommon, it's the lowest. I think it's, I read someplace 15%, but it's probably closer to 10% of recon appeals are approved. Very, very low, whereas like 50% of hearings and 33% at initial. So recon's pretty low. So don't be surprised if you get turned down, but don't give up. Keep appealing, but it'll be 6 months to a year. Places to find FCE forms. I think I've got one. Let's see, here's one right here. You can go there, and you can get them. And there's a couple other places. I put them all out there, but on previous live streams, but that's a good one to go to. So you can go and get a functional capacity form there. Okay. Maria, well, thank you, Maria. I appreciate that. And if you don't mind, I'm going to put this up now. Leave me a review. That would be very, very helpful. I really would appreciate that, because those reviews really help me grow my practice. And you know what? This live stream has been actually very helpful. I've gotten some really interesting feedback. Not every case is going to be something I can help somebody with, but I do get a lot of people reaching out, and I love it. So that's great. All right, Sandy is 59. Last job was a sedentary desk job. Have many issues. The one taking you out is peripheral neuropathy from chemo. Would that be grid rule 201.06, or would you find? Well, first of all, I would look at a grid, the light grids, 202 grids, because, basically the difference is at age 50, you have to be limited to even if you could do sedentary work, sitting 6 hours, standing 2 hours, lifting 5 pounds frequently, 10 pounds on occasion, you could be found disabled. At 55, though, even if you can do light work, so you can have a lot more capacity, is my point. you can have the capacity to do light work, standing and walking 6 out of 8 hours, lifting 10 pounds, frequently 20 pounds on occasion, you can still be found disabled. So it's easier to win at 50, 59 using the light grid rules. Let me pull it up here so I can show you what I'm talking about. Give me a second here. And okay, so this is the sedentary work grid. So basically, if you are able to do sedentary work, you can be found disabled. If you're light, you can do light work, you're not disabled. So you have to be pretty much at 50, to make this one work. I mean, at 55, you can still use it, but it'll work at 50. By contrast, if you go to the light one here, if you can do light work, again, which is a lot more capacity, standing 6 hours a day, lifting 20 pounds. Even if you can do that, you can still be found disabled. So, if you've got neuropathy where you can't stand and walk, then you can't do light work. So I use this all the time, 202.06. Basically, you're 55 or older, which Sandy is 59. High school grad or more, so you can have a college education. You may have a sedentary desk job. I'm assuming it's semi-skilled or skilled, not transferable because of pain, okay, or medication side effects, and then you are therefore disabled. So that's why 202.06. So I would argue 202.06 in the alternative, that's what they call it legally, you can argue that your functional capacity has been so reduced or so eroded by the combined effect of all your symptoms, the neuropathy, medication side effects, associated depression, maybe you have diabetes, anything else, the combined effect of all that stuff, all the symptoms would make you so unreliable, you're likely to be off task, is the phrase they use, for 10 to 15% of the day, or you're likely to miss one or more days of work per month. That will also do it. So I think that you could argue both the grid at 202.06. You could argue 201.06 if you want. No reason, it's basically the same thing. But again, if this one, it gives you is even more limiting. So I would say use 202, but use both. In fact, decisions I'll see, the judge will say, the grids apply at 201 or 202.06. And many times they'll say, but I'm going to find this person disabled because I think the combined effect of all symptoms would reduce functional capacity to a less than sedentary RFC, less than sedentary residual functional capacity, meaning that the combined effect of all that stuff would reduce your capacity such that you could not do even a simple entry-level sedentary sit-down job. But that's what I would do. I think I would argue 201.06, 202.06, and functional capacity. And I think that gives you a really good argument. I've had good results with peripheral neuropathy, especially from chemo. Obviously, there's a cancer involved at some level, but peripheral neuropathy may likely affect your standing and walking. You want to quantify those as much as you can, but I think that those, you've got a good case. I think that sounds like a pretty compelling argument to me. Okay, Rex says, is it difficult to get disability for severe OCD, generalized anxiety disorder, PTSD, and recovery from eating disorder? Rex, I would tell you that any mental health condition is difficult because you cannot image it. You cannot take an MRI of your brain and see OCD. So basically, in order to win, what you have to do is you have to have, evidence of significant symptoms. And what is that evidence going to look like? Number one, you need to have what Social Security calls a longitudinal or ongoing treatment record from a psychiatrist, most likely a psychiatrist who prescribes medicine, and or a psychologist, talk therapy. So you need to have, not just a few visits, like years of visits. That's number one. Number two is, I think there need to be other kind of indicia of severity. One of those might be failed medication trials, where you can show that you've been tried on 3 or 4 or 5 different medications with increasing dosages. Nothing seems to work. That's evidence of severity. It's non-responsive to treatment. Treatment resistant is what they call it. Other evidence of severity would be an inpatient hospitalization. suicide attempts. You need to have it. It's just got to be more than general anxiety disorder. It's got to be the point PTSD where you can identify very specific triggers. And you have evidence that you simply are non-functional when you're dealing with a flare-up of the PTSD. This is again where statements from third parties like former coworkers can come in very handy, because they can talk about Rex, when there was a fire truck goes by, the sirens and the noise, I can see Rex becomes very, very, disoriented and very distracted from work, and he would take 10 or 15 minutes, and he would have to walk around. I'm just making that up. You get what I'm saying. And the recovery from the eating disorder, again, what does that mean practically? Obviously, I'm assuming that what you're saying is that eating was a response to some of these other issues, that you severe depression, that you ate. So again, maybe then you've got medical evidence to say that you need to be avoiding even all but the most minimally stressful situations. Otherwise, it could trigger eating issues. Or maybe you had, anorexia where you were purging. And again, what would be the things that would cause that? So I just think that you need to identify those things that would interfere with you in a work environment. If you have really strong support from a psychiatrist and psychologist, maybe some non-medical support, that would be very, very helpful. But is it difficult? Yes, it's going to be difficult, because Social Security is a lot more comfortable with looking at an MRI of somebody's back and saying, I see 3 herniated discs. They're complaining of, severe pain with radiating into the leg, that kind of neuropathy. That's an easier thing to wrap your head around than to understand what it means to have OCD or anxiety disorder, PTSD. You have to kind of have evidence, just more of a creative type of evidence, I would say. Just had your hearing. Well, again, is it SSI or SSDI? SSI is not the same as Social Security. A lot of people call it, I'm trying to get SSI. They're trying to get on disability, but SSI is one type of disability, SSDI is the other. SSI is means tested if you have very little in the way of assets. So I'm assuming if it's SSI hearing, that would be, you're trying to get that. I think it's like $960 a month. It's not a whole lot of money. And they're subject to offsets as well. But regardless, whatever kind of hearing you had in the Social Security world, I hope it went well for you. And Rex says he's still in step 3, medical review. I've said this before. I don't think these, quote, steps mean anything. It's just a number. But they're doing the review, and normally it takes, it can take about a year to get a decision. They'll probably send you out for for some sort of a consultative evaluation. Okay, so Just Me said that the ALJ read into the record that your visual feels consistent with the stroke. You have a lot going on. That's very positive. I think it means the judge read the record and understands what you're going through. Would I recommend that if someone looks unusually young for their age, 57, like me, right? Like me. They don't do a video in-person hearing? Probably. I mean, I think judges are not really supposed to look at you and say, well, you don't look disabled. But if you think that your youthful appearance would be something that would be, noticeable to a judge, then yeah, do a phone hearing. That just takes that issue out of play. And I think that would be wise to do. It's not easy looking young like this, I got to tell you. Okay, Joe. Okay, Joe tells Lori to contact. Yeah, that's exactly right. Let's see here. Let me just put this other thing on. Oops, got the wrong banner here. Okay, let's go back here. Moonshine says, if I received a $20,000 settlement for workers' comp for proof of SSDI, how much will they deduct from your back pay? Okay, this is a tough question because, in fact, I had a case I'm working. One of my clients had a workers' comp settlement 10 years ago. So what does that mean? I'm doing the research on it right now. But big picture, most workers' comp settlements are going to have language in there that basically says this $20,000 is not $20,000. It represents, you know, $35 a week for your expected lifespan. If it's got that language, they call it Hartman language, Hartman. If it's got Hartman language in there, then it will not impact your Social Security very much at all. If let's say your benefit's $1,500 a month and they take $35 a month off because of the workers' comp, I can live with that. But if you don't have that kind of language in there, then that's when you run into trouble. They look at the months that you're getting Social Security. They start chopping off to take the entire month and do the offset. So it can eat up all your past due benefits is the point. So I think you want to look at your settlement and see workers' comp settlement and see does it have that kind of language in there. Doyle Rogers. Doyle, that's a great question. Can someone be a caregiver for an SSDI? Technically, a caregiver is a job. If you look at the Dictionary of Occupational Titles, it's occupationalinfo.org if you want to look at it. A caretaker is a unskilled job where you're sitting with an elderly person, or maybe you're sitting with a child or a disabled person, and you're just basically there to keep them company, to pick up the phone if there's a problem. That is a job. So if you're doing that for pay or not for pay, that could be considered substantial gainful activity. Now, if you're doing it not on a schedule, if you're coming and going as you please, if it's not something you're doing, again, the way you would do it for a job, it could be seen as more of a, not really SGA level type of endeavor. But I think if you're getting paid for it, or if you are, if you're either getting paid for it, if you do it on a regular basis, and you're the primary caregiver, I think that could be SGA. And I think if you're reviewed and they ask what you do, and you say, well, I'm sitting with an elderly aunt, the questions could be, well, you're not getting paid for that, but you could be getting paid for that. So yeah, I think it could be considered a job. You got to be careful with that. Joel, thanks for always being. Well, thank you, Joel. I try. I think there's not a lot of great information out there. Now, there are people who obviously do other live streams, and there's a lot of good information out there, but it's kind of hard to find. If approved for SSDI, can you decline? I don't know. That would be a question that you would ask a Medicare person. The person I work with when I have Medicare questions is a gentleman named Cal, C-A-L, Hero, H-E-R-O, that's his real name. Cal can be reached at, I think it's info@medicaremall.com, I think. Let me just check that. Medicare Mall. And Cal, yep, that's it, medicaremall.com. And Cal is somebody I've dinner with him. We've chatted on the phone. I've interviewed him for my podcast. Very, very knowledgeable about Medicare and all the different options with Social Security. And so he can answer that question much better than me. But I think that I don't know. I just don't. I would ask Cal. I just don't know. Okay, if you're on an SSI and have COPD and thyroid implant, okay, this is a question that I see sometimes. SSI and SSD have the same criteria. And the reason you'd be on SSI would be because you don't have enough credits for SSDI. So if you're on SSI and then you have additional medical problems, it's not like you take a step up and get on SSDI. Disability for Social Security purposes is all or nothing. If you're disabled, you're disabled, whether you have one disabling condition or 5 disabling conditions. Getting more disabling conditions after you're approved does not increase your money. It doesn't change you from SSI to SSDI. SSI, it's as of your onset date, do you have enough credits for SSDI? If you don't, being on SSI will not give you credits. So you're not going to be approved for SSDI if you don't have earnings credits. And if you're not working because you're on SSI, you'll never get the earnings credits. So I don't see that there's going to be a path to you get on SSDI based on what you're writing here. Just got an update report, says Chris. Should I be concerned about any further reviews? I think I've mentioned this before. There is a code that's assigned to your case, and it will say that you are that improvement is expected or not expected. So if your case has been coded one where medical improvement is expected, then you may get reviews every 3 years. Now, again, I've said this before. I think that when you hit 50 and 55, you're going to see less reviews. But, Congress puts a lot of pressure on Social Security to review claims. So, it's just one of these things where if you're coded for possible medical improvement, you may get regular reviews. And there's nothing you can really do about that if that's the way you're coded. So I think, yes, should you be concerned about future reviews? Yes, I think so. This is St. Louis talked about this, that the judge in the ALJ hearing said, well, this claimant can conceive a child, therefore she's not disabled. Well, that's obviously there's no correlation between the two, and that would be why it was reversed. Okay, good question, Maggie. Is an attorney needed for review? I've been on my SSDI for 3 years, 45. Wondering if I need to contact my attorney. I don't think it would be harmful to contact your attorney just to ask him or her, if there's any tips they have. But I think that, most reviews are looking to see, are you, earning money? And do you have now capacity to earn something at SGA level or more, $1,550 a month, in 2024? Or have you had medical improvement? So, if you've been going to the doctor, then, I think that would be helpful. Look, I have clients call me or email me about reviews. I'll spend a couple minutes with them. I'm not going to spend 2 hours, with somebody going over the review. If they wanted to pay me, I could do that, but I don't have time otherwise. But I don't know that it's a problem to let your attorney know you got a review, and do they have any information, any guidance as to how to fill out the forms or what you need to say. Many attorneys do. The dude is back. Good evening, dude. Jen is in Lincoln, Nebraska. They had frost. Well, Nebraska is, known for its extremes of weather, and Jen will send me pictures of, snowbanks. So it's getting to be cold there. I mean, I understand Nebraska is really very pretty during the summertime, but maybe not so much during the wintertime. Crystal, got your hearing date. You're so nervous. Will they say anything about my son who received SSI? He has autism. The question that could be asked would simply be, what type of care do you offer him? Are you taking care of him? Are you doing things for him? Are you helping him with school? You're helping him with, activities of daily living, bathing, clothing, food, toileting, things like that. That could be an issue. Then the other issue you got to deal with is if you get on SSDI, is your income, your SSDI, going to impact his SSI? That's sort of beyond the scope of what we're talking about here, but those are some questions you might want to ask. And maybe you'd make more in SSDI than he's getting from SSI, and the offset won't be an issue, but just be aware that it could be that. Brian, how are you doing, Brian? What are the pros and cons of LTD companies referring to SSDI representatives? What are the pros and cons? I think what Brian's getting at, Brian is of Brian Terry, the Disability Digest. We've known each other for many, many years. Actually met in person last year. What he's getting at is that long-term disability companies many times will refer you to a non-attorney rep, somebody that they have contracted with. Brown Services is one of them. There's a couple of them out there that get a lot of this. And so what they want to do is, because if you get on disability and you're on long-term disability, then whatever months you got long-term disability, Social Security will then offset it. So number one, you have to pay back the payments that you received from Social Security, the lump sum, if you got long-term disability for those months. And going forward, long-term gets to reduce what they pay you by whatever you're getting from Social Security. So it's a really good deal for the long-term disability carrier. By the way, the reason they're able to do that is the long-term disability carriers say, look, we're giving you a policy through your company. They reduce the cost of the premium, so they say, so they can offer an affordable, $15, $20 a month, whereas if you bought in the open market, it may be, $500 a month, something like that. So they're saying we factor into our premium cost or what you're paying in premium, the likelihood that you're going to be getting on disability. So Brian says, what are the pros and cons of this? Well, I think number one, you're dealing with companies that don't really have a vested interest necessarily in getting you on disability. They're there to help the insurance company. They may be reporting information about you to the insurance company, which might be used at some point to eliminate or reduce or cut out your long-term disability, so that you could be giving them information that can be used against you. That's number one. Number two is that many of these companies will not do hearings. I used to do contract hearings for Brown & Brown, for example, a number of years ago. They actually did a pretty good job preparing them. I'll give them credit for that. But they wouldn't do the hearing. So I would get the hearing, and I would look at it, 2 weeks in advance. I'd call the client, and so forth, and really treat it the same way I treat my own cases. But some attorneys would get it the day before they would prepare the case. So you may not be getting the attorney who's doing the hearing is not necessarily going to be someone who is associated with other than a contract basis. So that would be a concern for me. Third point is that since you're paying back the lump sum of the money that you receive from Social Security, that's the same months you got a long-term disability, they don't make you pay back the long-term disability. Does not make you pay back the part of that lump sum that went to the attorney's fees. So in fact, they're paying the attorney. So I talked to somebody today, for example, and this person's is applying for long-term disability and Social Security. Literally got fired today. He called me 20 minutes later, and his last day of work is the end of next week. Nice guy. He's got significant medical issues. And I said, well, you can I'd apply for long-term disability, apply for Social Security. Realize if you have me do it, it's not going to cost you a dime, because if we win, if you get on long-term disability, that's great. And if we win Social Security, you're going to have to pay back. Let's say your lump sum was $40,000, and you got to pay, and after the attorney's fees, it's $32,000 or whatever. You have to pay them back the 32, but the $7,200 that went to me, they don't make you pay back. So in fact, they're picking it up. So to answer your question, Brian, I think that, I'm more comfortable personally, this is just me, if I'm being represented by someone whose focus is on me, as opposed to reporting or having another, hand in the pot, an insurance company. Insurance companies are not in business to help you. I'll just leave it at that. So that's my take on that. What do you think? You tell me what you think. I'm sure you have probably a similar opinion, but I'd be curious as to what you think. Okay, Yuli. I'm about 9 months in on an SSDI case, had an exam get canceled, having a disc replaced. Should I be sure SSD gets the information about this? Absolutely. So if they cancel the consultative evaluation, that may be a good sign, because they realize that, you've got something significant going on. You're having a disc replaced. That is very relevant. Absolutely want to get that to them as soon as you possibly can. If you have a patient portal, download it right away and get it to them. Absolutely. DL. Okay. I got a call from Cisco. They wanted to do the evaluation. They already did 123. I had copies of that. Just email me. I can log in and get it to you. I had somebody do that just yesterday. She said, can you get me a copy of the consultative evaluation? Just email me, and you got my email, and just tell me what, if you remember the date in 23, and I'll just pull your file. I can get it in literally 10 seconds. I'll send it to you. St. Louis. On hospital portals. Yeah, portals are great, because, and I got to tell you, one of the things that it's really changed for me in the 30 plus years I've been doing this is, it used to be getting medical records was a real headache, because we'd have to mail away for them. And in some states, the cost of getting medical records can be ridiculous. I mean, $1 a page. And the margins in disability are just not that great, where I can't drop $500 in medical records. So we would have to rely on Social Security to get them. And of course, that takes more time, and then you got to hope they do it, and so forth. And so it was a real problem, especially when we're getting ready for a hearing to update records, because, let's say that, we had records from a hospital through, let's say May of 2024. I just needed records from June of 24 to October of 24. Well, they wouldn't just send me those. They would send me the entire file and charge for it. I'd have to go through and pick it out. It was just very time consuming. So you know, fast forward a couple of years, most medical facilities have portals where you can log in and our clients give us access. We can just download the information from the portal. That gets us those medical records right away without paying for it. It's a much, much easier way to do it. There's also a number of other things. There's something called the high tech law, which allows me to get them. There's something Social Security is really trying to expand on, is called the HIT, Health Information Technology. That's another way to get them. Very, very helpful way to get them. And of course, people can sometimes just go by and get the medical records. But I think that we use HIT a lot, Health Information Technology. We use portals, and really this has become a non-issue for us. And it's really, and Jen can speak to this more than me because that's what she does. But it's a real lifesaver. It's very, very helpful. And a few physicians don't have portals, and we just work around that. But the ones that do, most have them now. It's really, really helpful. Okay, Joseph, who reviews medical records like MRI, X-rays in my office? I actually have a medical doctor on staff. Her name is Iris. She is a medical doctor lives in Guatemala, but she is a licensed physician and she has her own practice. She does, and she works for me. Part-time, but a good number of hours. And what she does for me is we get medical records in, she reviews them, and she kind of summarizes many of them for me. I mean, I've done this for years, but she looks at it with a different pair of eyes, obviously different skills than me, as a medical doctor. And so it's very, very helpful to me to get those. And so she'll sometimes, call me or text me or something and say, take a look at this. This is something that's unusual. So that's who does it in my office. I mean, I do it when I review records for a hearing. I abstract the medical record, but right now having a medical doctor on staff is a really good thing. And I know other attorneys use services to do that. There's a lot of AI coming down the pike. I've tried a couple of these AI engines, artificial intelligence engines, where you dump the PDF into the AI engine and ask for a summary. I have not found one that I think is really, really compelling yet. I suspect that it's getting better. Everybody says it's getting better. But right now I've not found one. And so again, I just do it the old-fashioned way. I look at medical records and review them. I read a lot of medical records, and having Iris go through it, it makes it, really saves me a lot of time because she'll kind of abstract it down. Then I write my brief with that. I've got the file actually open with me too, so I'm looking at the actual records too. Okay, but that's who does it in my office. Roy's place. Roy's a longtime viewer. You have very good taste, Roy. Thank you. You've been educated, helped grow. Okay, great. Well, very good. Thank you very much. I really appreciate that, Roy. And if you would not mind, and please, I know I do this periodically, but if you found this helpful, leave me a review. There's a place you can, talk about the live stream, talk about the videos. That would be very, very helpful. It helps me grow my practice. So please go there and do that if you don't mind. That would be cool. But I'm glad that you found it useful. And I enjoy doing this because, when I first started doing these videos years ago, there was just not a lot of good information out there. And, quite frankly, as an attorney, when I was learning this, it's very hard to learn this as an attorney because you can't really go to hearings. Back then, all the hearings were done live. It's not like it's open to the public, and there's not that many attorneys who do it. So it was a challenge. And then as I got more into it, I realized how much misinformation. I mean, again, I'm getting, and I'm just example. I mean, questions people are asking me about, I'm an SSI, I want to get an SSDI. And again, it's a reasonable question, but that's information out there that people just don't know. So I try to share what I know about what works, the grid rules. I talk about that a lot. What works, what doesn't. That's why I do it because obviously I like when people hire me. That's great. But if you don't, you win. That's cool too. Leave me a nice review. That's great. That's great. Thank you. Thank you very much. Thank you, Roy. I really appreciate that. That is very, very nice of you, and I really, really do appreciate that. Referrals are great, and certainly if you do refer somebody, tell them to put in I've got let me put this up here again. The case evaluation. Just say, I heard about you through Roy or whatever, who was a visitor of your your videos. So yeah, let me know. I'd like to know where it's coming from. And actually the ones that I want to know which videos you find helpful. Gary, do the SS doctors take consideration when they see I've had a fusion on 4 disc and 2 pinch points? They can't get that I've done from 300 or 400 gabapentin. Gary, that's a great question. Here's what I would say is many of the doctors that Social Security uses for consultative physical evaluations, okay, are what I call industrial clinic doctors. Doesn't mean they're bad people, doesn't mean they're evil, but they, most of them do not have, or they work for review companies that do a lot of work with insurance companies. So their mindset is to minimize and downplay medical problems. They get their money from insurance companies who pay them to say this person doesn't need to be getting benefits. And so in the Social Security context, they take the same attitude. Again, having done this for 35 years, I will tell you that most of the time, and I'll go on a ledge and say most of the time, go out and put it out there, the physical consultative evaluations are garbage. They don't tell you anything. Or they're just so ridiculous, there's nothing wrong with this person when there is, evidence of disc herniations. So I wouldn't rely on those. I think most better judges don't rely on them either. You got to have something else. But, so the point is that in my opinion, maybe 10 to 15% of these consultative doctors might say, yeah, he's had fusions, he's had 4 discs operated on, he's on, ridiculous amount of Neurontin and gabapentin. He's clearly disabled. But you'd be amazed what some of these reports say. They'll just say, well, all that stuff, but he could do light work. So, it just is what it is. Now there is that doctor. Oh, and I knew I should have had him. The guy with the bow tie on YouTube. He is a. I'm just looking at my YouTube channel to see if I see him here. Sometimes he pops up. I'm just going to put a consultative evaluation. Consultative. Dave Foster, J. Dave Foster. And check out Dr. Foster's channel. He is a doctor, and I've chatted with him before. He is a doctor who does consultative evaluations, and he does them the right way. I think Dr. Foster is one of the very few who really takes seriously what he's doing and the implications of it. And so he talks a lot about, what he looks for and what you need to prove to the consultative doctor to win. And again, his name is J, the initial J, Dave, D-A-V-E, Foster, F-O-S-T-E-R. He has a channel. Let me see if I can just go to his channel here. I'm just going to copy it and put it in the comments here. But Dr. Foster is, he does it right. So the only criticism I would have is I think that he maybe assumes all the doctors do it the way he does. They don't. So, but it's a really, really valuable resource for those people who are dealing with consultative evaluations. Okay, Muley. Thank you, Muley. I appreciate it. Look, I hope you win. That's the most important thing. I hope you win. But thank you for the kind words. What did SS say? Johnny says, give him SSI instead of SSD, even you have your credits. Well, realize that credits for disability are not the same as credits for retirement Social Security. In disability, you have to have 20 quarters in the last, 20 credits in the last 40 quarters, generally speaking, 5 out of 10 years. So if you worked for 30 years and you stopped working 10 years ago, you will not be insured for disability. You'll be insured for retirement, but not for disability. So you need to find out what your date last insured is for disability, and then you have to have an onset date that is before that date last insured. So, like for example, I have a hearing coming up in 2 weeks, 2 or 3 weeks, I think. That was a brief I was working on. My client's date last insured is December 31, 2023. Her hearing is going to be in November of 24. So if the judge finds her disabled in April of 24, she gets SSI. I have a case right now that I'm talking to my client. We won partially favorable decision, but the judge found her disabled at age 55. The problem is that was after her date last insured. So I'm thinking what happened, Johnny, was that your onset date was changed by Social Security to some date after your date last insured. So if you have a chance to appeal that, you might want to look at that, but you want to find out what your date last insured, your DLI, date last insured for disability is. If you can get your My Social Security statement, ssa.gov/my account, that would be helpful. Now, many times when people have an active disability claim, you can't get it. That makes zero sense to me. I mean, that's John Oliver should have put that in his rant. I don't know if you've seen the John Oliver rant. It's really pretty funny. Let me give you a link there. John Oliver is a comedian, and he did this rant about the ridiculousness of Social Security that was a little bit R-rated, but it was very, very funny. And I'll put the link to it. I posted about it on my blog here. Let me just copy this. So I'm just going to put that in here, John Oliver. And if you have not had a chance to look at this, it's really very funny. But that's what I'm guessing is what happened, Johnny, is that I think that your onset date was after your date last insured. Mr. Gumballs, why is your case in recon for every 8 months? Is this normal? Yes, it is normal. Because Social Security doesn't have enough people, they're way behind. So yes, that is normal. Ridiculous. When I did this, 15 years ago, 3-4 months. Now a year is not unusual. KJ, my hearing's in January. I have the grid rules on my side. 58 meter listing. Still nervous about dealing with SS for 2 years. Kind of relax. You can never relax when dealing with Social Security. You could have, you could be literally on death's door and they could turn you down. Is it likely? No. Do your research on the judge. Obviously, if you have a reasonable judge, good chance. But being 58 is going to be a big help. You got the grid rules on your side, big help. If you meet a listing, which is hard to do. A lot of people think they meet a listing, they really don't. But maybe you do. That helps. Sounds, I don't know anything about your case, but it sounds like, just being 58 is positive. I will tell you, I've won cases for people 58, 61, 59, whatever, that I thought the cases were maybe marginals too a strong a word, but they would not be a case I would have taken if the person was 35 or 45, and we won. And I think the age is the big factor. The grid rules are great. I mean, I got to tell you, the grid rules are to me, it's one of the most powerful tools that I have to win cases, and I use them all the time. Pulmonary fibrosis, ICD placement, I'm thinking that's a pacemaker, ventricular tachycardia. I think that, now the question you're asking is, how do I get approved early? And I think the question there is, you need to identify the functional limitations in terms of your capacity, whether it's breathing, whether it's sitting, standing, walking, lifting, whether it's missed days from work. This is where a good functional capacity form could help. If you get your pulmonologist and or your cardiologist to fill one of those out, you'd be in pretty good shape. Let me give you a link here to a couple of places where you can get these. Bear with me 1 second. Here is, I'm going to just put the link here. Here's one that's got this attorney, Mike Merberg. I don't know Mike, but he's very generous when he puts out there. I'm going to put that in the comment section, but he has free functional capacity forms. And again, these are very solid. I like to customize mine a little bit, but sometimes I'll use the basic ones. He's got one on cardiac, so I'm not sure if he's got one on pulmonary issues or not. I don't see one on pulmonary in particular, but yeah, I think you could use one of these, maybe add a couple questions to it. And yeah, I think that would be a good chance to help you maybe get approved early. But yeah, if you get to a hearing, are you going to win? I think you have a good chance based on that. assuming that there are functional limitations. Rex, you are very welcome, Rex, and I wish you the best. I hope that you have a good result. Oh, good. Stephanie Joy. That's Stephanie's an attorney friend of mine. She is in Philly, or not Philly. She's in Pennsylvania, Stroudsburg, Pennsylvania, whatever that is, Stroudsburg, something like that. And I think that she does this solo, but we're friends through. She's got a LinkedIn group for disability attorneys and reps. We became kind of friendly, and so we chat a good bit about cases, just kind of bounce ideas off each other. Never met her in person. We chat by video chat and so forth. And I've had her on here before, but she's a very good attorney, and so she really cares about our clients. So there's some good ones out there, and she's one of them. Okay, MT. Applied for SSDI over a year ago, hired an attorney last month, severe lumbar scoliosis, 3 back surgeries, diabetic and peripheral neuropathy, ankylosing spondylitis, 41. All those conditions are significant, and assuming they're symptomatic would help you. The 41 is going to be the hard part, because Social Security makes it really hard to win if you're under 50. And 41, it's not like if you're 48, that would help a little bit. But 41 doesn't mean you can't win. It's just going to be an uphill battle. So I think it was a good move getting an attorney, and you're just going to need to have really, really solid medical. But, again, if you've had 3 back surgeries, peripheral neuropathy, diabetic neuropathy, ankylosing spondylitis, you got some stuff going on. So, I think that you may have a good argument. That's Red. How often does an attorney check a patient's, you mean not porthole, you mean portal, Portal. Porthole would be on a ship. So should I urge them to check it? I think that what I do is, when we have every email that goes out by my staff has a link at the bottom saying, if you have any new medical, and click here, and it takes them to a form they can fill out, tells about new medical. So I think that, you should certainly, every 2 or 3 months, if you've gone to the doctor, ask your attorney to download the new stuff from the portal and send it to Social Security. Yeah, I would do that. I don't think it needs to be weekly. Every 2 or 3 months would be fine. What information can someone find there? I think you must mean the file, the Social Security, I guess DDE. You mean the DDS, like the Disability Determination Services, Help to Reconsideration Appeal. Probably not much. We get access as an attorney. I get access to my client's electronic folder sections E and F only, which is some correspondence from the adjudicator and the medical records. Would it be nice to have access to more earnings record information, to know that, what their date last insured? Well, actually, we do know their date last insured from that. No, I don't think there's anything you're going to see in that rest of that file that you really need early on. I think mostly it's about the medical record. I don't think anything else is really going to be all that important. I don't think. Rip Titina. Oh, you're welcome. I'll just call you Rip. Thank you, Rip. I appreciate that. Chris Boyce says, you've had 2 reviews in the last 4 years now. The update report of brain damage and dementia. Yeah, it's doesn't make a lot of sense. It really doesn't make a lot of sense. I mean, I've never done this, but maybe what you do is you reach out to your representative and say, look, they've got me coded as a person to have medical improvement. Ain't not going to happen. Will you please ask them to change the code on my file so I don't keep getting these reviews? It's very stressful. It's unnecessary, and it's hard for me to do given my condition. And that's what I would do. I'd ask your elected representative to reach out to Social Security and to ask them to change how your file is coded. Okay, Wolf, this is a great question. I get these really, really good. These are questions I'm going to put on. I'm going to make videos about. Okay, so K. Wolf applied November of 21, and at that point was fully insured. And let's say that his date last insured is October of 2023, and he's got a hearing in January 25. As long as your onset date that the judge finds is before your date last insured, it doesn't matter that your date last insured has run. I take cases from people who their date last insured was maybe May of 2022. If I can prove they became disabled before May of 22, I can still pursue SSDI. So the key dates are not the date of the hearing, not today's date. The date is your onset date. When did your disability begin? Can you prove it? And then your date last insured. And your attorney can get you both those pieces of information. But as long as you can prove your onset was before your date last insured, you're good to go. John, how are you doing? What does not enough vocational information mean in denial explanation? I'm not sure that I've seen that phrase used. The only thing maybe you're asking me is there's nothing in the medical record that addresses your vocational limitations, perhaps, meaning that, you don't win a disability case based on your medical problems. You don't win on a diagnosis. You win if you can prove that you have vocational issues, work capacity issues. So maybe what they're saying to you is there was medical information. You had heart surgery, you have diabetes, you have, emphysema, you have, back problems, but there's nothing from any doctor that talks about the functional issues that arise from those things. That may be what the problem was, because you cannot assume that Social Security will extrapolate, you can only sit for 20 minutes because you have a bulging disc. It's not a correlation. You have to have your doctor saying, the bulging disc, the claim, my patient says that sitting for more than 30 minutes is, very problematic. He has a bulging disc and, additional things, and what he's complaining about, his allegations of limitations, are consistent with what I'm seeing in the medical record. You need somebody to put those two things together to combine. So K-Wolf, so again, I think I tried to answer you. You don't, as long as your date last insured, your onset date is before your date last insured, you're good to go. Again, my client that we have a problem with, she got approved for Social Security, SSI, as of her 55th birthday, but her 55th birthday was, let's say, in April of 24. Her date last insured December of 23. Then her date last insured was before her onset date. That's not good. You want the onset date to be before the date last insured. Hope that makes sense. You're welcome, K. Wolf. Okay, I think we just talked about that. Paul, question. Filled out a CDR review 55. Okay, so I'm looking at the 55. This is the simple form. Let's look at that together. And so you can see what he's talking about here. Okay, so this is what they call the short form. This is the SSA 455 short form. And you can see all it asks. Oh, I'm sorry, this is the short form. Okay, so it asks, since your onset date, have you worked for somebody, yes or no? If you put no and 0 there, have you attended school, you put no there. And, since whatever date, the date of disability, date of onset, or date of approval, you say your doctor has either not told you or told you cannot work. Basically, if you answer, no, 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 and the same or worse, that's going to be graded and gone to a doctor. Yes. If you answer those, it's going to be graded or by computer. It'll probably just be, noted as that you're continuing to remain disabled. Where you run into issues would be if you've worked, that may trigger a live person to look at it. That will trigger a live person to look at it. If you went to a school, a live person is going to look at it. If your doctor says you can work, a live person is going to look at it. If your health is better. So if you don't want a live person to look at it and you can truthfully answer no to all these questions up here, then more likely than not, your case will simply be processed on no change, your benefits continue. So I'm assuming, Paul, that when you say a score of low, that means that there's no indication you've gotten better or have improvement or doing anything. You may not hear anything for months. I think they do send you a letter at some point saying we've reviewed it and we've decided no change. But I've also heard of cases where they don't tell you anything. So who knows? But generally speaking, if you scored where there's really no change, you're probably in pretty good shape. I got denied, and my attorney wants to go to the appeals council, but I've been hearing that there's no point. Lose. What are your thoughts? I think that the appeals council is somewhat of a rubber stamp. And generally speaking, you'll probably have to go to district court. So, I think it's worth, what I do is I look at a decision, if it's unfavorable, and I see, is there anything that jumps out at me? Like the example that St. Louis talked about before of a judge denying a person because they conceived a child. To me, that's clearly reversible error. So I may see that. I may then also send it out to one of my colleagues, Carl Osterhout or Brian Konoski are the two that I typically work with. What do they think? And, depending on what they think, what we got, we may draft an appeal. But the assumption is we're going to go to federal court because the appeals council, we cannot assume they're going to do anything. Sometimes they reverse and remand. Many times they do not. But both Konoski and Osterhout do federal court work. I do a lot of work with Osterhout as local counsel here in Georgia, northern part of Georgia, for his federal court cases. So we kind of a ongoing working relationship. But I would agree that appeals counsel is kind of a waste of time to most degree, but federal court is not. And so you just have to assume you're going to be, in limbo for another couple of years. Okay. DMAX says, I have a stomach condition due to a surgical accident as a child. I've had job accommodations and SSDI for this issue. I'm guessing that's the California insurance. Do I send these accommodations? Yes, absolutely. Because that takes away from your capacity to do what they call competitive employment. If you've got it, if a vocational witness is asked the question, this individual can work, but only with an accommodated job. They have to be within, 15 seconds from a restroom. It's got to be available at all times. This person is allowed to take unscheduled restroom breaks 7 times a day. That's an accommodation. That's not competitive work. So to win disability, to lose disability case, Social Security's got to prove you can do competitive work. If you cannot do competitive work, because the only work you can do is accommodated, you win. So absolutely let them know about that. Okay, Crystal is the workers' comp person, has a question about comp. Okay, will Social Security go off the paperwork from workers' comp when it says I'm disabled, receive a settlement? No, they are not bound by any other agency, workers' comp, VA, FERS, nothing. They make their own decisions. So you could have, 5 agencies saying that Crystal is unable to do any competitive work. Doesn't matter to Social Security. They do their own evaluations. So it's, in fact, I don't think that a workers' comp finding is even going to be considered. They'll look at other federal agencies like the VA, but they're not going to look at a state workers' comp. Maybe federal workers' comp, not state workers' comp. DMAX says, Gary, get off gabapentin, try to get Lyrica, much better. It just depends on the person. I know people who have terrible reactions to Lyrica. But gabapentin is known for causing what they call GABA brain. I was talking to somebody, a pre-hearing yesterday, a couple of days ago, and my client's like, that gabapentin, she says, when I take it, I can't function. I'm just a total zombie. So I've never taken it, but okay, Jenny, we've been emailing back and forth about this. I'm reviewing it now. I know you sent me, I'm not going to talk about your case, obviously, online here, but I actually took that question and there are a couple other people that I want to run it by. My gut feeling tells me that because it's been 10 years, it's not going to be a problem, but I'm running it by a couple other people. So I'll email you back, probably tomorrow or maybe Friday when I have an answer. But I think because it's been 10 years, I think we're probably okay. But I will definitely let you know. But I don't want to talk about your case, obviously, in public here. Thank you. Well, my pleasure. Donnie Doomsday. That doesn't sound real positive, but okay. Are you Doomsday? I don't know. We live in a crazy world, I got to say. you read about all these people that call them preppers, and I used to think, yeah, you're a prepper. But I'll tell you, my wife and I talk about it like we have probably 10 to 14 days of water we keep. We got a bunch of canned goods. Just never know. We're going to get a generator. I mean, it's a crazy world out there. So, all these people that, I used to think were, a little bit off the reservation. I kind of thinking maybe there's something there. So maybe Donnie, you got it right after all, Donnie Doomsday. Meathead. I don't, that term, this is going to date me, but there was a TV show called All in the Family back in the 70s when I was a little kid. And there was a character played by, what's his name, Reiner, drawing a blank on his first name, Carl Reiner's son. But anyway, he was, now I got to look it up, okay, because I got to know. Rob Reiner, who's now a famous director. But Rob Reiner played this character named Michael Stivic, who was sort of a foil to Archie Bunker in All in the Family. And Archie Bunker, sort of the main character, it was very funny. Carol O'Connor's character used to call Rob Reiner Meathead. So that's when I hear Meathead, that's what I always think about All in the Family. If you haven't ever seen it, go to YouTube and just type in All in the Family and watch some of the shows. I mean, this was done in the 70s, but they could have done it now. It was great. It was a really, really interesting show, way ahead of its time. And I'm sure Meathead, being 55, would remember it. Okay, 55 years old, retired military, 100% disabled, knee and back injections, what probability to improve the first time? I will tell you the positive is you're 55, so the grids might very well apply here. At the same time, any orthopedic issue, knee and back, is hard because that's the number one thing the Social Security sees. They make it really hard to win. I would probably come down on the side that if you're 55 and you can meet the grids, you got a decent shot. I'm winning a lot of cases early on the grids more recently. So I'm going to come down on that. I think it's not a bad, odds are not terrible. If you've got, something that can show you're limited to light work and you got pain and medication side effects that would preclude transferable skills. I think you got a pretty good argument there. Gator. My case is the appeals council. I called today, this would be 15 to 18 months. There's no limit on time. That seems a little bit long. This might be a situation where you reach out to Senator Rubio or Senator Scott, and if you're in Florida, I'm assuming because you're a Gator. If not, reach out to your U.S. senators and say, why am I going to have to wait 15 to 18 months for a decision on my appeals council? Can you do something for me? Maybe they can, but that's a little long. I'm not waiting that long. I'll just put it that way. My appeals council cases, I'm usually getting decisions 6-7 months. So maybe they're telling you 15 to 18 months to reduce expectations. I don't think it'll take that long. Britea, I hope I pronounced it right. Britea. Oh, my pleasure. Thank you very much. Thank you for tuning in. Let's see. Now, if you lose, you go to the appeals council and you eventually win. So go to the appeals council. It can be remanded back, which means it goes back to the judge for another hearing, or the appeals council affirms the judge's decision, then it goes to the district court, who could also remand it. The problem is the first time around, it goes to the same judge. So if you have a low approval judge, that judge is going to get it again unless you move or the judge retires. The second time around, now we're looking at 3, 4, 5 years, different judge. But for some reason, Social Security has its procedure goes back to the same judge. Okay. DMAC, I've not been fully disabled since January. My back to surgical accident from a child still apply. Here's my take on that. If you are able to work, you obviously have this accident as a child, and you're able to work, is it possible that, as you've gotten older, your condition has gotten worse? Yeah, it's possible. But if you had a condition as a child that you're able to work through, you're going to have to prove why you can't work through it now. Now, the accommodation part, as I think you told me before, that is a different story. If you have to work with an accommodation, that gives you a much stronger argument. I don't know that you necessarily need to have the records from childhood. You could submit them, but as long as they're referenced elsewhere in the record that you had this surgical mishap as a child, that should be sufficient. I don't think you really need the actual records. If you can get them, great, but if you can't get them, no worries. Okay. Jetwing says, received a call from the local Social Security office informing you approved. Great. I appealed in January of this year, was in recon. So here's the case that got approved at recon. He was looking for your workers' comp info and insurance carrier. So yeah, if you had workers' comp, you want to make sure that you provide them the settlement and that it definitely talks about, you have that Hartman language in there that basically says that your lump sum payout is, to be considered over the lifetime of your expected lifetime, not just, the first 7 or 8 months. St. Louis Grand, super sticker. Thank you. I appreciate it very much. Is it normal yes, that's normal. Anytime they see workers' comp, they're going to want to see information. That is perfectly normal. Mike, schizophrenic, been waiting 11 months for SSI, taking many medications. All this in the hospital failed. Try to keep trying. Again, a tough question. I would say, you've shown you're compliant, you're willing to be compliant by taking the medications. I think it would be helpful if you had your psychiatrist basically say or recognize that the medications are causing unacceptable side effects. I would not go off your medications on your own without the guidance of your psychiatrist, A, because it's not safe to do so, and B, you don't want to come across as being non-cooperative and non-compliant. So I think, the answer is, if your medications are not effective and they're making you sick, you're not required to stay on them. But I think you need to do this under medical supervision as opposed to doing it on your own. Okay. Rajul, I have a question. I get approved for SSI disabled back pay. I was told it goes back first applied. It goes back to 12 months up to 12 months prior to the date of your application. So if you applied in October of 2022 and alleged onset date 2014, let's just make a crazy example. October of 22 is your application date. You can get paid from October of 21. So you can go back 1 year of date of application, again, assuming that your onset date is before then. So it's not just from the time of approval. Another misconception, you're not limiting it to 1 year from the date of approval. It's 1 year prior to the date of application, assuming the onset date is consistent with that. Okay, let's see here. RIP. My consultative doctor was nothing like Dr. Foster. He even said he performed tests he didn't. So basically, he said in the report he performed a test that he didn't perform. Gave me diagnosis, gives a lot of the claimants found by Googling his name. Yeah, and I think, what I do when I have a doctor whose report I think is garbage, I will on the record, on my opening statement or on my brief, I will say there is a consultative evaluation report from Dr. Jones. And this report, we're asking the judge or the court to give this report very little weight. It could be because the doctor, and you might have to put a statement to that effect, stated in there that he did, XYZ tests. The claimant reports he did not. The doctor said he, spent 45 minutes. The claimant said he spent 15 minutes. If you have evidence, I've, in my practice, Your Honor, I've seen, there are other reports from the same doctor. They're basically identical and you could attach them. There's a lot of ways to attack it, but bottom line is you want to ask the judge at the hearing to give that report very, very little weight. That's what I would do. KKK. Britea. I've been denied 3 times. If I win SSI, I would spend on my back pay, or is back pay not considered? Okay. For SSI, they divide the back pay into three different payments, which I think you get every 6 months. So you don't get one big lump sum. You get 3 payments every 6 months. That's they expect that you use up the first payment, within that 6 months, and then the second one. So that's why there's no back pay issue with SSI. SSI is terribly outdated. They need to change the numbers because they're limiting you to $2,000 of assets. If you factor for inflation, it would be $10,000. So SSI is a mess. Press the like button. Yes, please press the like button. I really appreciate that. Okay. Yes, that Mike is correct. It's while while that first installment is being spent, they don't consider it an asset, but beyond that, they would. How long does it take to hear back? It just depends. It could take 3, 4, 5 months. You may not hear back at all. But I'd say normally 3, 4, 5 months. Mr. Gumballs, my injuries were certified by the World Trade Center Compensation Fund. Don't know why I was denied. It was a documentation that qualified for compassion. I've had a couple of cases where my clients, I remember one guy who was a fireman, and he, went into the rubble, got denied. I think the World Trade Center Compensation Fund, those findings, they're not binding on Social Security, but they're relevant to Social Security. I can't answer why you're denied. I mean, again, the only thing I can think is, this is 2001, and obviously some of the conditions manifest themselves later, but you're able to work presumably after that. And, maybe this just the Social Security people just feel like there's not enough of a link between what happened to you on 9/11 or around that time and, what's going on the next 25 years. That could be what's going on. Okay, you are welcome, Mr. Gumballs. Luca Prozzi from The Godfather. Does a heart murmur? Probably not. I think that, again, a diagnosis does not win your case. A heart murmur is, many times can be functional. If it causes significant problems, maybe. But you'd have to really identify what those problems are, that they are frequent enough to keep you from being reliable, and they are impactful enough to prevent you from working. Dave says, started collecting payments June 23 and family received back pay, received mine yet lower to the high amount over $50,000. It's possible that they want to double check the math. And he says in a third signature, that is possible. I don't know that that's possible. Again, reach out to Greg Brinkley. He probably would know. Greg at gregbrinkley.org. He might very well know. Or Ed Weir might know. But it's very possible. I've not heard that, but I don't know. Yeah, my condition's not in the blue book. You mean, and I've got a website called metalisting.com. You can look at the blue book. But any careful examination will show a catastrophic damage, only 35, work my entire life. Don't know if I should get help. Again, without knowing anything more about your case, being 35 makes it an uphill battle. It just does. You've got to have medical conditions that are very, very serious that create functional limitations. T-Cash applied for SSDI. Wine God's name, they want my high school transcripts. Graduated high school in 1982. The only reason I can think would be if you're alleging either some sort of a mental health issue, ADHD, depression, anxiety, going back to childhood. They want to see that it existed back then, and that maybe you had to go into special classes. It could be because the grid rules could be implicated. Realize that, being a high school grad versus not being a high school grad make a difference. And if you are at special classes and didn't have a regular high school degree, which the transcripts could show, that might help you. If there was problems with attendance back in high school because of the condition, that could be relevant. Any number of reasons. If you can get it to them, just get it to them. There's obviously a reason for it. My guess would be that, excuse me, either it's because of some long-standing condition that goes back to high school and that's relevant to them, or they're trying to fit you into a grid rule, which is beneficial to you. Okay, Jenny, great question. What if your comp settlement was only for part of the disabilities you're claiming for SSDI? It offsets offset. So if you got workers' comp for a back problem and now you have back, knee, shoulder, and wrist and something else, it doesn't change anything. It's a good question. It doesn't change the calculation. If there's offset, there's offset. But again, yours is 10 years old, so I'm hoping there won't be a problem. But I'll know hopefully next day or so. You say, well, 10 years, no credit. Yeah, you're going to have a hard time because if you don't have enough credits for SSDI, you're only going to be SSI. If you have assets or a spouse that works, offset, no SSI, attorney's not going to take it on a contingency fee. That is just the reality of it. Again, because there's no way to get paid. If you have no SSDI, no past due benefits there, and SSI, if they're 100% offset by assets or household income, no past due benefits, no way to get paid. What is the one-time payment for SSI just approved as recon? Check my, there's a large amount of money. Thought you had to wait for a while. Again, and I could be wrong about this, there is a certain threshold. Well, first of all, I think that all SSI payments are paid in installments, 3 installments. So this may be one of 3. You may get more. It may be that below a certain amount, they don't have to break it into 3. I just don't know. But that would be my thought. But it's always nice to wake up, look at your bank account and say, there's money in there. That's a good thing. Paul, you are welcome. DMAC is in college. You know a lot of work. Again, I don't think that going to college, part-time is inherently SGA, but that's going to be a question that's going to be asked. If you're in college and you're going close to full-time or doing a complete caseload and you're doing something obviously that requires a lot of concentration and thought, that is going to be a factor. Because if you can do college part-time, could you do an entry-level, simple, low-stress job full-time? That's the question. So being in college is relevant, I think. Christina is in California. Christina, thank you very much. Christina, send me an email. You've been so nice to come on. Just send me an email. ssdanswers123@gmail.com, just so I've got your contact information. Jamie Gahn. December is the case decision for my appeal. When can I receive a letter? I'm not sure why you think December is the decision for your appeal. When can you say approve this December? I mean, I'm not sure why. Your premise confuses me, because why do you think it's definitely going to be in December? It may or may not be. The Social Security doesn't pin itself down to particular dates. Thank you, Christina. That is true. Please like, share, comment, subscribe. Walmart does not pay workers' comp. Well, realize that any company by law, and obviously every state's going to be different, but if you're hurt on the job, you're supposed to get paid. Missed wages, or you're supposed to get paid for medical care. Some employers are known to be a lot more difficult to work with than others, and I would agree. My understanding of Walmart is that one of the more difficult companies. They have a lot of employees, and they suspect they're really concerned about fraud. But if you are legitimately injured on the job and you have a good attorney, it ain't their choice. They got to pay. So that's what I would tell you. If you really got hurt on the job, there's good evidence of it, you got to fight them. You got to fight them. My wife does comp, and some of the stories she tells me are just ridiculous. Okay, once they start requesting medical records, how long before I get a decision? Again, on average, best case 6-7 months, more typical 12 months, maybe 15 months. And if they request you to see their doctor, usually they do that kind of in the middle of the process, 3, 4, 5, 6 months in. But, I would tell you to expect to wait. I would tell anybody who's applying, assume a year. If it's better than that, that's great. If it's worse than that, it's unlikely, but assume a year. Accommodations, DMAX accommodations from Apple. And again, I don't think it matters who the accommodations are from. The point is you're getting accommodations that allow you to work due to a childhood injury. So, and the accommodations may take you out of competitive work. Okay. Nini Brown, you are welcome, Nini. Can you file? Yes. Can you file your claim for Social Security retirement if you file a claim for disability? Yes, you can. And that way you get money coming in right away. And at that point, the 62 Social Security is going to be about 75% of your full, whereas disability is approximately equal to full. So what you'll be fighting for will be the difference between early retirement and full retirement. But you can do it if you need money coming in. GABA brain is real. That's what I've heard. I've never taken the stuff. Hope never to have to, but I understand it's pretty intense. Robert, good evening. Thank you, Robert. I appreciate it. Yeah, I mean, we didn't have too bad of a weather here in Atlanta. We had a little bit of wind. I did not lose power at my house. There were some branches knocked down. Some lower lying places in the Atlanta area did get flooded. So there was definitely some flooding, but I'll take that back. We have a crawl space in my house and it got wet. So that was really because there's it's like a mud embankment that it's starting to fail, I guess. So we got some mud in there, so we're gonna have to fix that. But I think that we got pretty lucky. And my house happens to be on a little bit of a hill, so we almost never get flooding. We would never get flooding here. If we got flooding, I need to build an ark. But never had flooding here. But a lot of places got it really, really bad. And the problem with flooding is especially if you're not expecting it, you don't have flood insurance. Insurance is going to cover it, and you could literally be wiped out. I mean, it's bad. Water damage. I mean, you get mold. Now, I have had that happen in my office one time. We had a pipe burst behind the wall, and we had a mold. We had to bring in this whole remediation crew, and they sealed off the office, and we couldn't. It was a mess. So flooding is bad news. But thank goodness, Robert, we did not have any real problems, at least where I live. But a lot of people that were not as lucky. Daisy, 58 years old. Okay, so the long-term disability. So basically, if you win, and every month so let's say you have an onset date of, I'll just pick a date, February 1, 2024, and you were getting long-term disability from January of 2024. So whatever lump sum you get, you have to sign it over to the long-term disability carrier because they paid you full amount when they're only obligated to pay you the difference between what your contract calls for in Social Security. So you got to turn over your lump sum, but you don't have to pay them back the attorney's fee part. So if you had an attorney representing you and the attorney was paid $5,000 or $4,000 or $7,000, whatever the number would be, then you don't pay the insurance company back money you did not receive in hand. So that's how the offset works, assuming that there is, that's a company provided policy, not an individual policy. Christina, okay, if you get denied, the next step is to file what is called reconsideration. And that is the first appeal. It's got to be filed within 60 days, 60 days of your denial. Kay Wolf says it's a great show. Well, good. Thank you very much. I appreciate it. And again, just to remind everybody, almost 100% not going to be on next week because I'm going to be out of town eating pizza and playing tennis with my buddies. We go every year. So if I, for whatever reason, decide I'm able to do it, I can swing it, or something happens and I can't go, I'll put it out there. But if you don't see me next week, look for me the week after. F. Adkins, I remember he was the son-in-law. Who is the son? Now you lost me here. Who is the son-in-law? Not sure who you're talking about there. Okay, so you're stopping at work. Okay. Good, good. Okay, thank you, Robert. I appreciate that. Thank you very much. Terry, remand case. Got my local congressman involved. Is that good for me to? Yeah, absolutely, absolutely, Terry. Our Congress people, and everybody bitches about them because they're all corrupt. They're all, and look, many of them are just hardworking people that are trying to do the right job, right thing for their constituents, whatever party they happen to be. And whether you're Republican or Democrat and your congressperson is the opposite party, they want to help you. I don't think that they're, well, you come from a district that votes, against my party. I'm not going to. Doesn't work that way. They want to help you. And the old joke is that everybody thinks that everybody in Congress is corrupt except for their congressperson. Look, some of them are corrupt, and some of them are corrupt with things that are much bigger at stake than a Social Security claim. But most of the time, they're willing to help you a little bit. So if you can use them, that's what they're there for. Let them earn their keep. Let them earn their keep. Christina, she likes all the. Well, you know what? Like I said, it's really, it's one of these shows that literally was not. I mean, all the. I think Rob Reiner is still alive and Sally Struthers is still alive, but this is a show from the '70s, the early '70s, long, long time ago. But it's had such an impact on TV, and a lot of the shows that have come after it, and it's just like I said, even though it is, some of the stuff, is a little cringeworthy on there. It's just a really, really neat show because it just addressed a lot of things, kind of a generation gap. You have to look at it yourself, but the character of Archie Bunker, just classic. I mean, it was Seinfeld before, a different kind of humor, but it was that big. It was just a huge, huge phenomenon. And if you have a chance to, look at it on YouTube, take a look. You'll find it's better than a lot of stuff you see on there now. I'll say that. Still a meathead, okay. And so Rob Reiner is still a meathead on Twitter. Yeah, I don't really, Twitter. I got to tell you, I post to Twitter. Honestly, it's automatic. I don't really do very much live. I think it's such a damaging thing. I mean, I get what it's there for, but the problem is people tend to follow other people that echo what they think. And so you're talking to an echo chamber and people say things they would never say to your face. And it's just like, you know what? It's just such a negative energy on Twitter or X, whatever they call it now. I just don't get it. I mean, I really just don't get it. I mean, it's just such negative energy. And so I just don't ever, I really very rarely look at it. I mean, I'll look at it, I may do a search for a hashtag about Social Security. I may follow other lawyers, a couple other people I follow. I'm a photographer. I may follow some photographers. But the political stuff, it's just bad news, in my opinion. Okay, your husband just reached out to Senator Cruz in Texas. It's been 11 and a half months, no agent assigned yet. That's ridiculous. And what Sabrina is saying is they haven't even assigned an adjudicator yet. Literally, all they've done is they've opened the file, it's sitting there, not literally, but figuratively on somebody's desk. They haven't assigned, but they haven't started working on it yet. So it's been 11 and a half months, and the case is just sitting there. And that's what, let Senator Cruz write a letter, and let's see, maybe he can get some response, get some action. How does the submission of discrimination form affect your claims? Will slow it down? I don't think it will. I think it's completely independent of your merits of your case. If you think there was discrimination by a judge or by someone in Social Security and you want to pursue that, I think that is completely separate from the merits of your case. I'd like to think so. Hopefully it is. I think that it is, though. Well, surrendering a life insurance policy, not SSDI, it could affect SSI, will not affect SSDI. SSDI is only concerned about earned income from working. Okay, just Jake. I have a son named Jake. I'm assuming that's not you. I live in Gwinnett, and he lives in DeKalb. Would one of your attorneys be able to do walk-in referral on Friday? Email me or just fill out the form, the contact form, and just let me know who you are. And we generally do most of our client intake by phone, just because since the pandemic, people don't really want to come in. I work at home a lot, so and actually Jen is in Nebraska, so really we're not. I mean, have I done walk-ins? Yeah, I have a meeting with a client tomorrow, as a matter of fact. But just email me using the contact Jonathan link. Let me know who you are, that you're just Jake, and tell me a little bit about your case, and I'll follow up with you. Okay. Jenny is supposed to go to a mental exam in person. That now the exams are mostly done in person. This is a good thing. It's typical. It's not good or bad. It's pretty common. How long will the decision after the exam? 6 months, 7 months. It just depends on how busy. As you saw, Sabrina's husband's been waiting 11 and a half months. They haven't assigned an adjudicator, so it depends on where you live. But it could be, I would tell you after the evaluation, maybe 4 to 6 months. Okay. That's okay, Jenny. Thank you, Christina. Let me put that up here. We're getting a little low on time here, so I'll just put that up there. But please, yes, leave me a review. That would be great. That would be great. Okay. All right, DMAX, stomach conditions gotten worse. Okay, well, and again, these are just things that show that you've deteriorated, and that you're, even with accommodation, you won't be able to work. Yes, Brian, he emailed me the other week, wanted to know when he could come on. I just need to get with him. It'll be, well, obviously I'm not going to be on next week. I'm shooting for November at some point, because Brian is a really sharp guy as far as, and I've interviewed him on my podcast about appeals, and I think you guys might find him useful in talking about some of the issues he sees on appeals. So I'll try to get him on. Now you've reminded me, I'll try to pin him down to sometime in early November. Yeah, I mean, Carl has been on my podcast. I may try to get him on here, or Lindsay, his wife. We do a lot of work, or Eric Berger is another attorney in their firm I do a lot of work with. So yeah, I need to, honestly, I get busy during the week, and then I wake up and it's Tuesday, and I'm like, it's too late to ask somebody to come on. So I need to just be a little better about that, and get people on. I'm trying to there are a couple of attorneys that I think that everybody would like here. I've had Stephanie on. There's a couple other ones I want to get on, and I'm going to do that. I'm going to try to make it where I have a guest at least once a month. That would be helpful. That would be the goal. King's daughter been denied Social Security twice because I went to the doctor and yeah, this is a problem. If you don't go to the doctor, Social Security assumes there's nothing wrong with you. So there are many reasons people don't go to the doctor. Again, traumatic experience in the past. And I get that. The problem is, if you don't go to the doctor, there's no medical record to win. So it's going to be problematic, unfortunately. So you sort of have to go. Fong Trong, retired military, just got total unemployability, P&T, granted chronic lower back pain, SI joints. Again, you don't say how old you are, assuming you're over 50. The 100% VA rating is not going to be binding on Social Security to get you to the front of the line. You'll get a faster decision. It depends on how bad what does the MRI show? Is your back pain, is it mechanical? Is it disc? Is it a bulging disc, a herniated disc? Is there nerve root impingement? Do you have stenosis? It just depends on the severity of it. Back pain, SI joint pain, again, how bad is it? It's a matter of degree. But I think, as a starting point, these are things that lend themselves to objective evidence. That is a positive thing when it comes to Social Security. So depending on your age and what the evidence says, I think that's a positive there. Cancer baby, step 3 means nothing to me, because I just think they just make up numbers. I don't think it means a darn thing. Okay, now again, King's daughter, if you have not worked in 8 or 10 years, you may not be insured. So you might want to get your My Social Security statement and see if you're still insured. Yeah, so, have you been working? And the back pay would only go back 1 year prior to the date of your application. But you're not going to be able to reopen a 10-year-old case, no. if that's what you're asking. No. What are the chances of getting approved in appeals court? Not great. I think it's remand, I think, was 10% last time I checked. But that's pretty low. That's like at the recon level. That's pretty low. Yeah. So again, what I would tell you is that, you want to get your My Social Security Statement, ssa.gov/my account. Are you still insured? That's really important to find out, number one. Number two is you've got to go to the doctor. You have to have medical record to show what's going on with you. And you have to have support from your doctor to show that it's disabling. That's what I would tell you. Christina's seen Jody's YouTube channel. Okay. So yeah, Jody is workers' comp in Georgia. I'm sort of the producer of her videos. You can see it's the same similar background. So we'll come up with topics. You see my camera back over here. You can't see the whole camera, but it's camera back over there. I'll kind of direct her. She'll answer questions and we produce it and get it out there. And it's been good for her practice too. So, but yes, if you have workers' comp in Georgia, not elsewhere. Gabber brain is real. Yeah. Weird stuff. Ken, very good. Thank you. I hope it does. Thank you. Hope it stops love information. I hope I will. I'm looking forward to it. Again, it was 3 other guys. We all played tennis together for years, and one of them has a family condo down there. And so, our wives were like, go, have fun. We eat too much. We joke around a lot of trash talking, and we play tennis and, walk on the beach. And it's just, it's 3 or 4 days, but we've kind of made a tradition out of it. And it's just, like I said, I don't really drink. I don't gamble. I don't go to Vegas or anything like that. Just not my scene. So, going to somebody's condo and playing tennis for 2 or 3 days, that's my boys' trip. All right. Grid rules. Well, okay, you're sort of asking a couple of different things. So district court will send it back. Grid rules, if you go to gridrules.net, you can look it up. But basically, it just says that even if you have some capacity for work, you have to have a physical impairment. You can't use the grids for mental health. It's got to be physical. Assuming you have some sort of a physical limitation, even if you have capacity, the grid rules recognize that a person over 50, over 55, over 60, and it kind of breaks at these different ages, that the practical matter, you're not going to find a job. That's what the grid rules do. So even if you have capacity to do some work at certain levels, you still win. Before 50, when there's no grid rules, then you've got to show you can't do any work at all. With the grid rules, you could be, if under grid rule, 201.14, you could be able to do sedentary work, sit down work, sitting 6 hours, standing 2 hours, lifting 5 pounds occasionally, or frequently 10 pounds occasionally, and still be found disabled. That's why the grids are so powerful. You can still have capacity to work and still win. At 55, even if you could do light work, you still win. So it's very, very powerful. But look it up. Now I'm not saying I'm a saint. That's a bit much. But happy to answer questions. I like to do it. Thank you, Hollywood. Appreciate it very much. King's daughter. Yeah, no, I get it. Again, you have to see if you're insured. That's a really, really important thing. Cool, Elizabeth. That's awesome. So you got your forms done correctly, approved first try. Excellent. Okay. Lymphedema. Oh yeah. I like lymphedema cases. They're winning cases, I think, because they cause swelling. Obviously, you can't really do a whole lot. Very painful. That's great. It could. Fifi Earth Wanderer. That's a YouTube handle. I like it. Fifi Earth Wanderer. I can't even imagine what that means, but I like it. Final review of application. Okay. 32, applying for mental health. Again, those are tough conditions. Tough conditions. You were 40, Elizabeth. Wow. Well, lymphedema, that's pretty. There are certain conditions. Lymphedema, irritable bowel, certain cardiac conditions, I'll take them. I don't care how old they are because they're winners. My experience has been that's one of them. Okay. How do I find it? There's not really a website. That's the problem. I mean, you can go to ssa.gov/myaccount. You can download your My Social Security statement. That will tell you if you're still insured. But otherwise, there's not like a website you can go to. You might be able to call Social Security and ask them, but I would get your My Social Security statement. That's what we recommend our clients do. So, okay, so we are now at 10:30 my time. It's been 2 hours. So I'm going to close it off at this point. Again, not here next week, almost certainly, or if I am, it may just be for a very brief time, just to stop in and say hello, but I think I probably won't be. But I'll be back the following week. So everybody have a safe, now that fall's kind of kicking in, have a safe early fall. And, if you have any questions or anything like that, here's the link to get the review. Let's put this in here for case evaluation. So please let us know. We're happy to try to help you if we possibly can. And Jen is saying I'm amazing. I write Jen's paycheck, so Jen has to say that, right? So, okay. All right. Well, anyway, I hope everybody has a really, really good rest of the month of October, and we'll see you in November. And again, if you need anything from me, reach out this way, and I'll do my best to get back to you. So I'll call it a day now. Everybody take care. Bye-bye.